Now, Laurel, without further ado, help us understand all the comings and goings with complaints on the board.
Hello, I'm so glad to be with you tonight. So glad to see some of my friends. Carrie Riggs, oh my gosh, she and I go back like 20 years, I don't know. And there's a few other people I see, David Mora, and I know I can't see everybody who's attending, but I just want you to know that I love seeing old faces or previous faces, and just love getting to know new people. I totally am up for any questions. I love the fact that y'all have sent me a few to start with. We just have an hour, right, Kate? Wow. Okay. So I need to get started. So here are some questions from the Texas Counselors Group. What is the best practice to navigating custody agreements when treating children? Oh my gosh. So funny thing is I just purchased from Vistaprint. Oh, just a second, I've got to get it. Because so many people have a question about this issue. So I just printed this little handout. I don't think you can see it. It just says, do you know that your BHAC license requires that prior to beginning counseling services with a minor client, you obtain and review a current copy of the custody agreement, blah, blah, blah. This has been a law or a rule since 2012, and I still get a lot of questions on it, which is totally fine. But I recently just printed out like a jillion of these little note cards to send out because it's so important to get that custody order, because it really gives you information about what you need to do when seeing that minor client. Now, there's a difference between what the rule is with your LPC board and then what best practices. Totally different things. So I think it's important to know both. So the rule is you have to get a copy of that custody order. You have to follow that order. And I can spend an hour and a half just on that. So I won't go totally into it. I do have webinars almost every month. And I have a webinar that I offer every year called Working with Divorced Parents. And so if you follow me on Facebook, I will give up-to-date information about your practice, also give you information about the webinars that I offer. And best practice really when you're working with divorced parents is to always copy both parents. I know that one of the frustrating parts is the other parent is out of the picture. What you need to do at the minimum, best practice, is to contact the other parent, let them know you're in the picture, let them know their child is receiving counseling, reach out to them. And that is really the best way for you to avoid a complaint from that random parent who really isn't involved, because you don't want them to find out and be totally surprised that the child is receiving counseling and that you haven't tried to reach out to them either by email or by phone. Does that Kate, answer the question?
I think so. And I see different variations on this question. If the child is adopted, if there's no custody agreement on file, right? So lots of but I would like to post your information in the chat so everybody knows how to contact you, because I know your webinars are so informative, because then you can spend a whole hour on this. But can you touch on that? What if a custody agreement is not available and that kind of thing?
Certainly. So first of all, it's understandable that therapists think that they should get a copy of adoption paperwork because it is an order from the court that you're adopted. However, that is kind of an exception because when a parent adopts a child, they become basically like the biological parent in the way that they have all the rights and duties. So if they're adopted, you do not need to get the paperwork. Their birth certificate will be changed to read the adoptive parents' names. You do not need to get any paperwork in that situation. Parents will sometimes tell you that, you know, we never got married, we don't have paperwork. One of the questions to ask is, has anybody paid any child support? If they paid child support, most likely there is a court order somewhere. Also, if there is a protective order, if there's a restraining order, those are things you're going to need to get, or you're going to need to look at to figure out maybe if there is some wording in there about conservatorship or custody.
So we got a question in the chat. A school counselor wants to know, giving short term, she calls it tier 2 counseling, not tier 3 counseling. Do you also have to have a copy of the divorce decree?
That's a really good question. Good news is that school counselors get very, very few complaints. So when I gauge how important a rule is, a lot of times what I will look at is, if you violate that rule, what is your exposure? Because what I want to do is protect all counselors, right? I want to help them make not only a best practice counseling office, but I want to help you avoid getting a complaint. So, yeah, I mean, the good news is school counselors don't get a lot of complaints. I understand that there are different gradations of school counselors in therapy. It's interesting that the LMFT board is considering having a CEU requirement for crisis counseling. And so, you know, Lord knows if the LPC board is going to follow or not. But I think it's interesting that they're having some sort of emphasis on what is crisis counseling versus what is, you know, office consent, things like that. So the good news is, if you really don't see that student on a regular basis and have a therapeutic relationship with them, you probably don't need to get a divorce decree. One thing you might be interested in if you are a school counselor is looking at what forms the parents have to fill out at the beginning of the year. For instance, I was a school counselor with Dallas Independent School District for 3 years, part-time. Well, I was an attorney. And so one of the things that was involved was that, you know, at the beginning of the year, they signed all these different forms, and one of them was a consent for counseling. So I think it's also important, if you're a school counselor, to find out what have they signed about counseling before school even starts or before I see the student.
So one of the questions has another nuance. So it says, even if the order says both parents have equal rights, you still need the custody agreement, right?
Well, okay. Let me see if I can see the question, because I don't really understand.
Can I clarify, Kate?
Sure, go for it, Dana.
So what I'm saying is if someone brings you an order and they have joint custody and both of them have equal rights to provide medical, psychological care, whatever that standard wording is, you still suggest that we call the other parent, even though the order says either one of them has the right to obtain those kind of services?
Okay, so yes, Dana. So the rule requires, if it's independent rights, you only have to get consent from one parent. Best practice is that you contact both parents. Because another thing too is that when parents have independent rights for counseling, rarely, but this does happen, rarely one parent takes the child to counseling with one counselor and the other parent takes the child to counseling with another counselor. And so that's one reason why it is helpful for you and for your notes to show that you have done due diligence just to make sure that everybody's on the same page and you're not missing a link, meaning either a parent or you're not missing another counselor.
So
That makes sense.
Thank you, Dana. So we've got one, can a parent upload a picture of the section for custody agreement, or do we have to have the whole document for it to count?
Perfect. Good. Very good question. So unfortunately, what has happened when there's just, let's say, a partial decree that is sent to a counselor, let's say the first 5 pages in a decree, generally contain the psychological rights. If you only get the first 5 pages, what you don't know is whether the judge has actually signed the order or not. Whether the judge has actually signed the order or not, whether it is a valid order. It can be that the attorneys just passed it back and forth, back and forth, back and forth, and just sent it to the parent. Whether they thought it was a legitimate order or not, I'm certainly not going to speculate. But there have been times when I receive an order and I say, I have got to see the judge's signature page. I've got to see that to make sure it's a valid order. And there are times when I've been able to check on the decree and I find out it hadn't been signed, and that what the parent is showing the therapist is not a valid order. So at a minimum, you would need the first part and the signed page. In this day and age with technology, I wouldn't see why you couldn't just get the whole thing. And just, I mean, it's a PDF. So parents can get a copy of the order if they say, well, I don't have a copy. Well, all you have to do is pay $5 at the district clerk's office and you get an entire copy. So it's really not that hard to get a copy if the parent says they don't have a copy. Yeah.
So Daniela says also, if a parent who has custody but is an alleged perpetrator, she personally would not want to contact that person. What do you recommend? But assuming they both have equal rights, what do you recommend in that case?
Okay, well, so I'll tell you a quick story. I was representing a dad in Collin County Family Law Court. The mom had gone to a particular therapist who I know now, really good therapist. And the mom had told this therapist a bunch of stuff. I did not know what actually was really going on. So I had the dad ask for a copy of the child's counseling notes, and the dad got those to me. And what the intake showed is that mom said dad basically committed family violence. He was the perpetrator. She was scared of him. The children were scared of him. And what I knew and what I later shared with the therapist is that the mom actually had a conviction for domestic violence and the father did not. And so I really, really caution you against believing what one parent or the other parent has been doing unless you know for sure. Now, if there's nothing to say that dad's a perpetrator, I would absolutely contact him. First of all, even when there's a protective order in place for domestic violence, very, very rarely, or I want to say I have never seen your right to get counseling records affected, your right to communicate with a counselor affected, your right to consult with the therapist affected. It is not affected. And just because there's a protective order between mom and dad does not mean there's a protective order between dad and the kids. Now, some counties, some judges think, well, if dad's violent to mom, he can't see the kids either. For instance, Collin County does not believe that way. Other counties do not believe that way. Just because mom and dad, there's violence between them does not mean that dad is going to be violent to the children. So I think that there are a lot of variables to look at. And I think contacting dad and getting maybe his version of things is maybe helpful, important, and give you information about how reliable a reporter the mother is. Just my thoughts.
Okay, we have a question. What if they have equal rights? Parents have equal rights. One consents to counseling, one does not.
Well, so what it sounds like you're saying is they have independent rights. And best practice would be to get both on board. Some therapists refuse to see the child unless both parents will sign a consent. I totally understand. And that's mostly therapists who do forensic work, meaning in the courts. And so, I can understand why that's best practice. Doing it that way cuts down on complaints. If you get both parents on board. If the rights are independent, there's different kinds of rights. There's independent rights. There's subject to agreement, which means you have to have both parents agree. There is sole or exclusive, which means only one parent has the right to consent. So those are basically the three biggest types.
Wow, that was a lot. I think that's all I see in the chat for this particular issue. I'm watching. I don't see anything else. What else you got for us?
All right. So, what documentation do you maintain besides the ROI if you get subpoenaed to testify for a client from a previous employer and you agree to testify? Well, okay. So I guess I would want to break this down. If you get subpoenaed, what that means to me is that you are personally served with a valid subpoena and that the subpoena states a particular date. You get paid for your subpoena time, for your time in court, whether it's a deposition or getting your records together or testifying in court. You do not need an ROI if you are served with a valid subpoena. Now, does it help to have an ROI? Absolutely. Previous employer, though, if it's more than one person, then it's going to be difficult to get an ROI because, an ROI really shouldn't say, this is an ROI for Apple computers, because that's like a lot of people. So if it was just, you know, a one-person business, then you could have the name, you know, Kate Walker LLC or whatever, PLLC. Yeah, that I'm not sure if there's any other nuances that I'm not seeing. So I'm open to thoughts from y'all. Oh, and do it. DA's office subpoenas. How do we get paid for that? Yeah, good luck, right? Good luck with that one. You
Well,
just don't
and so
accept
you just talked about this.
you don't accept the subpoena, you know, I guess that's the way.
Well, you just talked about this in your Facebook group today or yesterday. It says a related question, but can subpoenas be served by email and fax now? So you were talking about all the ways they couldn't be served, right? So is fax and email okay?
Okay, so fax is not okay for service of a subpoena. So I think what some people may be getting confused about is maybe faxing an original petition, serving a party with an original petition. That doesn't work for a subpoena of a non-party witness, which a therapist is going to be a non-party witness. Non-party meaning you're not either mom or dad, you're not anybody named in the lawsuit, but you are a witness, so non-party witness. With email subpoena can work in criminal cases only, and that's only if you acknowledge receipt of the subpoena. So my suggestion, whenever DA's office, investigator reaches out to you, you don't answer, right? You don't answer. So they can serve criminal cases subpoenas by email, but yeah, civil cases they can't. Civil cases, all you can do is personal service. That's it. Now you can agree to receive the subpoena, and basically what you're saying is, I am not going to challenge the fact that this is not a valid subpoena, is what you're saying when you agree to receive a subpoena that way. I do not suggest people do that. The reason is because when you receive a subpoena by personal service, what happens is the process server goes back and files an affidavit with the court. And then the affidavit with the court will say, I served Kate Walker on this particular day at this particular place. And then everyone is put on notice that you were served. The judge will be put on notice that you were served. Both attorneys will be put on notice that you were served. So to me, it's a lot cleaner that way. And that's what I generally tell therapists that they should do.
All right, we've got a question about a minor client. If a minor client is being seen from a divorced family and mom is self-paying and has been given receipts, do I have to provide super bill or receipts to the dad if he requests it and they both have independent rights?
Yes, 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 yes. And that is a rule in the LPC code. And I have my rule book right here. Let's see, this is psychologist. This is professional counselors. It's going to be somewhere in here. But if I have time or if I am able to do that, I will look it up and tell you. Let me see. It's going to be under the billing section, I think.
Is it just for each client, a licensee must keep accurate records, or is it a particular section for
No,
minor
there's one that says you've got to, upon request, you've got to give it to mom or dad. Yeah, there's one specifically about it's actually, I think, the one that contains you've got to get the order, wherever that one is. I should have put that number on here. I should have put it on my card, but I didn't. Yeah, you absolutely. You've got to treat the parents equally, regardless of who's paying the fees. Absolutely have to treat them equally. As far as consulting, as far as getting copies of the records, as far as informing them about what's going on. Yeah.
Okay, so in lieu of more questions going into the chat, because I know we're going to have more, you do have some stats for us. What
Well,
are some common complaints?
oh, okay. So I sent you those handouts. I don't know if we can do anything with them today.
Do you want to share screen, or do you want can try to pull them up as well?
I think I can find them. I don't know. Can I share screen from here?
If I make you a co-host.
I mean, you know me. I mean, I'm old. I don't know technology at all. Okay, and let me just say at this moment that Kate Walker has the most exciting life. So I love following her, seeing all her traveling and different instruments that she plays. And amazing.
Well, I'm actually in El Paso today.
Are you?
All right, let me
Okay.
see. I can pull.
Yeah, go ahead and do that. Can you make, I've got my screen.
Okay.
Am I like a person now that I can share?
You can, or I can.
I got it. I think I have it. Can you see that?
Oh, you got it. You're there.
Am I? Okay. Can everybody else see it? Give me the thumbs. Oh, thank you, Daniela Prado. I like that name. Okay, so by looking at this, I want to explain a little bit about what this is. This represents, as you can see at the top, 86 complaints reviewed at an ISC. An ISC is an informal settlement conference. All right, we got somebody in our waiting room. Did you let them in?
I did.
Yep, we got that.
Perfect.
Yeah, don't worry about that. We got that.
All right, you know, I have to control everything, right? So this does not account for probably 50% of the complaints that BHEC receives that are either dismissed or they are handled like as a warning letter, which is a non-disciplinary action, meaning the public does not find out about it. So let's say, example, we'll give you a couple examples. So let's say I was seeing therapy clients. One of my clients made a complaint about the fact that I was wearing an orange shirt and they did not like orange shirts. Okay. That would be dismissed for non-jurisdictional reasons, meaning that it really doesn't have anything to do with what's in our rule book. It doesn't have anything to do with counseling. So that would be dismissed on non-jurisdictional grounds. Another example of when something would be dismissed is when there is insufficient evidence. So let's say mom files a complaint against therapist and then therapist, I'm just trying to think because I just had one dismissed this week. And mom says something like, therapist did not develop treatment plans. And then the therapist is able to get a copy of the file to BHEC, and it shows that she went over the treatment plan 3 different times with the parents. So that would be dismissed for insufficient evidence, meaning it does involve a rule. However, either they found the rule was not violated or there was not sufficient evidence to find that the rule was violated. So another example, kind of going down the line, is in seriousness, is let's say confidentiality issues. So I'm talking on the phone to Kate Walker and I start talking about one of my clients, therapy clients, and I reveal confidential information and I shouldn't. That's probably a bad example because then Kate would have to go turn me in. So, so Kate turns me in, and B Heck is like, that was really a bad thing. But we know Kate is like a stellar person. She would never tell anybody any of my confidential information. So we're just going to put a warning letter in Laurel's file and say, Laurel, really, you should do better. And we are putting this in your file just in case some other issue comes up with confidentiality. You have been warned. I mean, this is kind of this, the finger pointing, right? So kind of the next in line, and it's so funny because I was watching the social work board meeting on Monday morning, and they talked about the fact that they don't do conditional letter of agreements anymore. And I'm like, what? What? What are you talking about? You don't do conditional. I don't know what they call it. All I know is that, Miss Benitez, the attorney, tells me, Laurel, if your client does 8 hours of ethics or on boundaries, then I'm going to dismiss your case. To me, that's the same thing as a conditional letter of agreement. But anyway, whatever makes them happy, as long as they dismiss my client's case. So those are kind of those are the steps that are non-disciplinary action, meaning they do not go to the public. The public does not know that any of that stuff occurred. Now, if you go beyond that, generally there's an ISC, meaning it's more serious than Laurel speaking out of turn with Kate Walker, or it's more serious than, maybe there's some confusion about whether a treatment plan was present or not. So these are the more serious ones. So when it looks like 86 only, that's a little bit misleading. And that's why I go through that long explanation, because there's a lot more than 86 cases. Right now, I think the LPC board is like, it's not up to the 400 yet for LPCs. I mean, I think it's like 358 complaints they've gotten since last, I think, don't they run October? It's September 1. Yeah, it's September 1. So they start counting in September. So the September complaints come out with the following year number on it. It becomes very confusing. So sexual misconduct always is the most biggest complaint issue that they deal with in disciplinary actions. Why is that? I do not know. If anybody has any idea about why sexual misconduct continues to be the number one, please feel free to share with me. Interestingly, on this one, dual relationship was third, not second. It's usually second. And I can certainly give you examples of dual relationship if we have time, if you want.
Laurel, I got a question. So have they started sectioning or, somehow pulling out data where these things are happening with associates in private practice? Because I thought Christina was starting to gather some of that data separately from, the rest of the big blob of data. No? I
would love that. I have not heard that. And now, the boards only have meetings like 3 times a year. And so, I mean, the trickle of information is a little bit less than I would like. But if you heard that, that would be awesome.
Well, I don't know. And I thought I heard Christina say, oh yeah, we've started collecting that, but I could have misheard. I was listening on Zoom too. So
well,
all right, we have enough.
What I can tell you is this: I try and follow complaints, And I do not recognize a spike in complaints regarding LPC associates since they have had their own practice.
That's good. That's good to know.
I do not notice any uptick. I notice that people, therapists are still sleeping with their client. Therapists are still
number one.
It's still number one. They still let their clients live with them. It's a continuous issue. Please do not let your clients live with you, okay? Because I guarantee you're going to get a complaint of dual relationship.
Laurel, I'm going to go back to the chat. We've got a chat question that's kind of long, so if you can see it, but I'll read it. It says it's related to couples. Couple is married but working on divorce. Wife called wanting statements for all family members, wife's individuals, husband's individuals, and kids' individuals. I got the guy feeling it was for her attorney, but she would not tell us. Wife was on husband's consent. I wanted to treat the statements as part of PHI, but when I consulted with all other providers in my office, they all said they have never filled out an ROI for statements. Should I have gotten her to do an ROI?
Wow. Okay. So I recently posted about this on my Facebook page because so much confusion about it. And let me see if I can well, I don't know if I can find it. I recently posted about it. So in the situation where you have a husband and a wife in counseling together, in family, in couple, whatever, they are separate clients. You absolutely may not disclose husband stuff to wife. You may absolutely not disclose wife stuff to husband. I actually had a complaint probably last year that included the fact that, and this was one of several things in the complaint, so I'm not suggesting BHEC totally dinged this person, but I was representing the therapist before the board. They had gone to couples counseling, and then they had gone to individual sessions with the therapist. Wife, in one of her sessions, asked therapist, when was it that husband came in for his individual session? I don't know why she needed to know. Anyway, the therapist responded, and the LPC board dinged that therapist. You cannot disclose confidential information about another client. And husband and wife are two different people. They're two different clients. Now, when it comes down to kids, I mean, if it's their children, if mom is the mom of all the children, yes. I actually had a case recently that was dismissed where therapist was seeing like 3 kids in the family, but one of them was actually a stepchild of the dad. So biological mom to 3, dad was biological to 2, and stepfather to 1. And the complaint was made that therapist was disclosing to father information about the stepchild, and BHEC did not like that. So I think it's really, really important to identify who your clients are, identify what their rights are, and make sure you protect those relationships. Does that kind of answer the question? Okay, let me go ahead since I can't really hear Kate. So
Okay, I'm back. My Wi-Fi died.
here's a good one. And I told Kate I did want to talk about this. If you add coaching or online courses to your offerings, should you create completely separate LLC, and or how do you make sure you are operating with integrity with your licenses and when you're in other roles? Woo, okay, we only have 15 more minutes. So I'll try and make this quick. So right now, I have a case in front of SOA with the LMFT board. The LMFT board believes that coaching is part of their license. So what that means is if you are doing coaching and you're an LMFT, you cannot coach outside the state of Texas. It also means that when you are a coach and you are an LMFT, that you have to get a consent form, you have to keep progress notes, you have to do a treatment plan, you have to keep up with your billing, you have to keep your records for 7 years, all that rigmarole. I have a case in front of SOA right now. I'm waiting for the decision. I mean, this has been like a 2-year freaking battle. And so I should have I should have the decision by the end of July for sure. So it may or may not, the judge may or may not make some sort of decision about the coaching issue. There are a few other smaller issues involved. By my accounts, I think they're smaller. And so the judge may say, I'm going to discipline you for this smaller issue, basically because they don't want to decide whether coaching is a part of the license or not, which I wouldn't blame her for doing that. So my concern is, one, I want to get the word out to people who are LMFTs about this particular issue. And two, I'm concerned that because the boards are trying to standardize, meaning have similar rules across the boards, I'm concerned that it might be affecting the LPC board in a way that they might consider it. They might say, well, I can kind of see that, that's kind of using the license. So a lot of unknowns at this point. It's probably more unknowns than what is really known. The BHEC argued that coaching is a part of LMFT. I argued that it's not. They had pretty good evidence. I, of course, had a pretty good argument. I mean, if you don't have good evidence, you got to have good argument, right? So we'll see what happens. And please follow my page because I will definitely be posting about it on my page. I do want to mention that I do have a webinar coming August 23rd, which is a Friday. It's with a business attorney that I work with, Jeff Mullins. And I'm happy to put his information in the chat towards the end.
Post the information on how we can register for that.
Oh yeah, well, you have to follow my page.
Okay. On Facebook, right?
Yeah. Or you can go to my website, but I don't think I have it up yet. So what we're going to talk about is the Corporate Transparency Act. Raise your hand or indicate if y'all have heard of that before. Corporate Transparency Act, perfect. There's a couple. So everybody that has a PLLC, some sort of corporate formation, has to file this particular form before the end of the year. And it's basically to make sure that you do not have a terrorist organization. Okay. The government is always thinking up new ways to get your information. It's also going to be talking about non-competes and how the FTC, Federal Trade Commission, has made some new rules about non-competes and how they're pretty much void or going to be void after this rule is finalized. As a employer or as a business owner, if you have previous contracts out there with non-competes that include non-competes, you have a duty to actually reach out to those contractors or those employees and tell them that they are no longer bound by the non-compete that is contained within the contract they have with you. So those are two pretty significant things. I am not a business attorney, but Jeff Mullins is going to help me with that. I've had him on several other webinars, and he's just like a ton of great information. So the two webinars I have coming up, one August 23rd with the business attorney, and then after I get back the ruling from SOA about the coaching situation, I'm going to have a webinar about that. Whenever I have a webinar, I do give out CEUs, mostly ethics, but sometimes not. For instance, when Jeff comes, it's not ethics, it's just regular CEUs. When I talk, it's generally ethics, because then we're talking about the rules and how to follow them.
So Laurel, is coaching on the 4-year rules review agenda at all?
I don't think so. And I think really they're just now starting to do the rules review anyway. I mean, they're scheduling the town halls now. So, I mean, we are just now starting, and I'm getting my list together of rule recommendations. I know BHEC may not like all of them, but
I recommended a couple too. All right, so we have a dual relationship question. A family member referred to me someone they know professionally. It's their client for services they offer. I don't think that is a dual relationship, but just wanted to check with you.
So you have the therapist has a business relationship with them?
No, the therapist client. Danielle, you want to explain?
Yeah, my family member offers services to this person, and they refer that person to me for therapy.
So is the question, is it a dual relationship for you, or is the question?
Right. Is that a dual relationship for me?
Do you have any business relationship with the client?
No.
Okay, well then it doesn't sound like it should be.
That's what I thought. It's like if I have two roles with that client, but I just wanted to check.
Yeah, no, I mean, it's always a good thing to check. So I don't want to see Daniela's name, up against the dual relationship, bar and graft in the future.
We've got an out-of-state question from Anthony, and I'm assuming that's probably the same answer as if it was counseling out of state, right? It's up to the other state, not us. So it says, if I'm an LPC, can I do coaching out of state?
Yeah, I mean, generally, I don't know of any other board that thinks they regulate coaching. So what I'm going to say is that I'm like 95% you can do it. Sure, you can do it. The MFT board thinking that they can regulate coaching. I mean, the MFD board is just like, they're like a loose cannon over there. I mean, I'm just like, it's like they're a train and they're on the edge. They're like, and their wheels are like causing sparks. And I keep wondering, like, when are they gonna like catch on fire? Or are they just gonna slow down and like be inept and do nothing? It's gonna be one or the other. So I'm just watching.
Hey, I like them right now because they align their supervisor training with LPC. So that made me happy. We've
We'll
got
take
a question. Well, I got a question from Rena. I'm an LPC. I want to go into coaching. I was told as long as I don't use a diagnosis, I would be okay.
Well, so yes, I agree with that. In fact, I actually have a email that I got from another therapist that Daryl wrote to her saying, if you're an LPC, all you need to do is have separate consents. I would go a little bit further in my consent and say, I am not doing therapy. This is not therapy. We are not talking about your diagnosis or treatment of your diagnosis. And if you need to go see a counselor, I will refer you out. I think that, I think that needs to be in your consent just to be more cautious.
And we have another out-of-state question. At some point, I heard we can do telehealth for our clients for a very short time once they move out of state, while they find a new provider in the new state.
Well, that really depends on state to state. I think what I heard or read is that in Florida, you can do it for 14 days. So you just have to check with the state that they move to. I mean, their rules are as different as our rules are. So yeah, you just need to check with that other state. There's no blanket rule that applies to all states.
And to follow up, also at some point I heard as long as the client was still a Texas resident, but in a different state on vacation or business, we could do telehealth, but that's not a thing, right?
No, I mean, I think at the beginning of COVID, there was a lot of confusion, understandable. I mean, COVID confused everything. So that was understandable that we were very unsure, very unclear. I think what we really need to be clear of is the fact that both we need to be in the state and the client needs to be in the state. And it's interesting, the social work board actually has a more clear rule about telehealth than the LPC rule is. So, because the social work board actually says you have to be, in this state, where I don't think the LPC rule is quite as clear.
No, it's not clear at all. All right, we only have 3 minutes. So Laurel, take a look at the last 2 questions. Which one you want to answer?
All right, let me see. Gosh.
Shelley and Julie.
Like, oh, okay, Julie, I feel like I need to pay you for this question. Where are you, Julie? Julie is my new best friend. So thank you, Julie. In creating initial paperwork, do you recommend that we have those reviewed by an attorney? Of course I do. I will tell you real briefly. I do review, paperwork. I tell the therapist they need to send me every single document that their client signs. So that includes credit card authorization, that includes, telehealth, that every single document. And that it takes about an hour and a half for me to go over the forms with the therapist. So generally what happens is if they want to go through a form, what I call a forms review, they send me all the forms, PDF format. I download the forms and go over those forms before we meet by Zoom. And then when we do meet by Zoom, it usually takes an hour and a half. Rarely it takes less than an hour and a half. Sometimes I have to schedule another appointment to go over the paperwork with the therapist, but generally it's an hour and a half long. And I schedule them several weeks out. They take a little bit more brain power than I would like. So I don't schedule too many at a time. What is your fee for reviewing documents? Okay, Daniela, I like this. This is Daniela Prado again. Where are you, Daniela? There you are.
I'm right here. Sorry about all the questions.
I love the questions. I love the questions. Do you have anyone that writes forms for us? Okay. So my rate is $300 an hour, and that means whatever that involves. If you call me about, should I make a CPS report? If you call me about a subpoena, if you call me about forms review, it's going to be $300 an hour. It's just easier for me to get a certain number. Do you have anyone who writes forms for us? Stephanie asked that. My response would be no. And that is because different people have different practices. I mean, rural, urban, kids, adults, you know, couples. There are just so many different types of practices and preferences that the therapists have that I certainly want to incorporate. If I just handed out forms, y'all may not know which ones you need to do with your practice, or not understand or not recognize how you can personalize those forms to fit your practice. So, yeah.
All right, Laurel, I'm going to end it there. Y'all do two things for me. Number one, I want you to click the form right now, click the link, because when I shut down the meeting, that's going to be gone and you need that open in another tab. And number two, find Laurel's Facebook page. She posts great information all the time. She's very generous with her information, generous with her time, and attend her webinars. They're fabulous. They're informative. When she goes to TCA, attend her TCA programs, and just can't say enough. And thank you all for doing something amazing on a Thursday night. Just kind of showing up at dinner time and learning some new things. Remember, Step It Up members, you guys will get the replay as an asynchronous CE because you're awesome. You're all awesome. So I'm Dr. Kate Walker. Thank you guys so much for joining. And I will see you next month for Mark Tovar. And I will see everybody soon.